and we are hoping that we are rebuilding a resource base that can be used by a number of stakeholders in advancing digital rights on the continent. So as we start, my name is Hlengiwe Dube. I am also at the Center for Human Rights as the project manager of the Expression, Information and Digital Rights Unit. And I'll be moderating this particular event, and my co-moderator will speak later on. Her name is Maristella. She will introduce herself when the time comes. So for now, I just want to hand over to our Assistant Director, Lloyd Kuveya. But before Lloyd speaks, I just want to give you an outline of how we are going to proceed. So we will start off with our Assistant Director speaking, and then we'll hand over to the African Commission on Human and People's Rights Special Rapporteur on Freedom of Expression and Access to Information in Africa. Thereafter, we will get into the session where we are launching the report. After the launching of the report, we'll have a brief conversation around one of the areas that is raised in the report, which is that of surveillance in Southern Africa. So that is how we are going to proceed. Right now, I just want to give the opportunity to Lloyd to introduce himself and also just make brief remarks on behalf of the Center for Human Rights. Thank you.
Very good morning to everyone, and thank you so much, Hlengiwe, for the introductions, and welcome to everyone to this report launch. And I believe this is really an important report, specifically and especially for the Southern Africa region, where we have seen some perhaps retrogressive laws that have been enacted and that have had an impact on rights in the digital sphere. The COVID-19, I think, in a way, exposed the digital inequalities that exist within the Southern Africa region in particular, and a lot of people suffered and were disproportionately affected, in particular children going to school and other internet users, because one realizes that in certain countries, issues such as inadequate infrastructure, issues such as the high cost of data in some of the SADC countries, which is quite astronomical, and issues such as inadequate infrastructure itself, technological infrastructure, to ensure that there's adequate internet access, that has really caused a lot of these inequalities. And really, I think in a way, COVID-19 exposed that. And the vulnerable groups, I think they really need the support and protection of governments around the SADC region. But it's not just the vulnerable groups such as children and to a certain extent women perhaps who have suffered, in terms of issues like digital violence and so on and so forth. But also you find that people such as journalists and activists have suffered in a way, because usually they've relied on online communications to do their work. And at times when they critique or they speak out against certain governments, they've really faced a lot of political reprisals in the form of arrests and persecution. And really, I think, as Hlengiwe stated, the promulgation of oppressive cyber laws in the SADC region is particularly worrying. And I think, and I hope that this report speaks to some of those issues, and looking at how perhaps countries in the SADC region can begin to reflect and reform some of these cyber laws that are oppressive and have an impact on right to freedom of expression, access to information, and other rights in the digital sphere. And as the Center for Human Rights, we are really grateful and appreciate our continued partnership with the African Commission on Human and People's Rights. And really the African Commission has taken a lead in developing over the years soft laws, guidelines, looking at access to information and freedom of expression, including access to information during elections and so on and so forth. And therefore, we really appreciate the initiatives undertaken by the African Commission on Human and People's Rights. And in that vein, I would like to particularly thank the current Special Rapporteur on Freedom of Expression and Access to Information in Africa, Honorable Topsy Sono. And really thank you so much for taking the time to be here and gracing us with your presence. We really appreciate you. I would also want to, at this stage, thank ALT Advisory, and in particular, Slindwe Kumalo and the co-author, Mary Hunter, for really coming up with this report, drafting this report, which I think is going to be quite critical in not only raising awareness on the issue of digital rights, but also in coming up with recommendations for policymakers in the region, and also to targeting our governments in the region so that they can begin to do the right things and protect people who are using the internet, and also protecting their rights in the digital sphere. So thank you so much to the team from ALT Advisory. We really appreciate you. Usually when such good works happen, they don't just happen without the funding that is required. And in that vein, I would really at this stage want to thank Freedom House under their project on advancing rights in Southern Africa, ARISA, for providing the necessary funding that is required for this project really to become a success. And lastly but not least, I really want to thank the team at the center in the Expression, Information and Digital Rights Unit, led by Tlengiwe, for really conceptualizing this idea of developing a report that looks at digital rights, the digital rights landscape in Southern Africa. Thank you so much, Tlengiwe and Mary Stella and Tomiwa, for really conceptualizing this project, and also the hard work that you put into just editing and also reviewing the great work that was done by Slindiwe and Mari. And so without wasting much time, and we should perhaps now get into the meat of this report and listen to the experts who have drafted the report, and also listen to our Honorable Commissioner, so that we look at this report and officially launch it. I'm really excited because at a personal level, the next steps, which are really important for us at the center, is the advocacy. And I think this report will provide that guidance and awareness to many activists who would want perhaps to take it forward and conduct advocacy in the respective countries in Southern Africa. I wish everybody successful deliberations, and I hope that this report will not just end with the launch and the webinar that we have today, but that it will develop legs and really influence policymakers in the SADC region and our governments to do the right thing and ensure that there's protection, not just offline, protection of rights offline, but also protection of rights online. So thank you so much, and I hand over back to our moderator, Tlengiwe. Thank you very much.
Thank you so much, Lloyd. We will certainly begin the next steps of the report on the 15th of August with our initial training. So indeed, we are going to make use of the report. Thank you. With the Center for Human Rights, we've been privileged to work with the African Commission on Human and People's Rights, which is the body that has been mandated by the AU to oversee issues on human rights. And specifically for this session, we've worked with the Special Rapporteur on freedom of expression and access to information in Africa, and we've seen the work done by the different mandate holders from Advocate Pansy Tlakula, Lawrence Mute, Jamasina King, all these instruments that were developed, the model law on access to information, the Declaration of Principles on Freedom of Expression and Access to Information in Africa, and also the guidelines on access to information and elections in Africa. And now we have Commissioner Topsy Sunu, who is the new mandate holder, and she's building on the work that was done by her predecessors. And she's not developing a new instrument for now, but she's taking up the advocacy role and popularizing the existing instruments. And this mandate was established in 2004. It has been in existence for since that time. And mainly its role is to, among other things, analyze media legislation, policies, and practices in member states. Also, the mandate undertakes investigative missions on access to information and freedom of expression on the continent. It also makes public interventions where violations on access to information and freedom of expression have taken place. And also during the sessions of the commission, the mandate holder submits reports which gives an indication of the status of freedom of expression and access to information in Africa. So briefly, that is the role of that mandate. And now I'm going to hand over to the commissioner to give us her remarks. Thank you so much, and over to you, Commissioner.
Thank you very much. Good morning. So I am honored to participate in the launch of a report on digital rights landscape in Southern Africa in my capacity as the Special Rapporteur on freedom of expression and access to information in Africa, a special mechanism of the African Commission on Human and People's Rights, the Commission. As a member of a regional body for the promotion and protection of human rights in Africa, my mandate as the Special Rapporteur takes particular interest in digital rights and their interaction with freedom of expression and access to information. At the outset, allow me to extend my sincere thanks to the Center for Human Rights for undertaking this important study and for inviting me to participate in the present launch. The right to express oneself, to receive, seek, and impart information is entrenched in international law, as well as in many domestic laws across the African continent. Article 9 of the African Charter on Human and People's Rights, which we call the African Charter, provides that every individual shall have a right to receive information and the right to express and disseminate his opinions within the law. Whereas the African Charter does not specifically refer to digital rights, the Declaration of Principles on Freedom of Expression and Access to Information in Africa, the Declaration, which was adopted by the Commission in November 2019, is a key development in this regard. The Declaration affirms the principles for anchoring the rights to freedom of expression and access to information, and further addresses major pertinent issues which emerged over the past 2 decades, notably the interface between Article 9 rights and the Internet. The revised declaration thus sought to bring Article 9 of the African Charter into the digital era by including provisions relating to Internet access, privacy, surveillance, and data protection. Digital rights are basically human rights in the digital era, comprising the rights that are implicated during the access and use of technologies. It is now firmly entrenched that some rights that people have offline must also be protected online. This was noted in a resolution issued by the UN General Assembly in 2011, and similarly in the Commission's resolution on the right to freedom of expression, information and expression on the Internet in Africa. The internet is one of the most powerful tools for facilitating the receiving and imparting of information and ideas. It allows for instant sharing of volumes of information across borders and to disseminate same to wide audiences. The internet also enables individuals to engage with diverse views and perspectives and to access an array of resources to assist them to formulate their own views. In 2011, the four international and regional special mechanisms for promotion and protection of the rights to freedom of expression came together to issue a joint declaration on freedom of expression and in the internet, which stressed the transformative nature of the internet in terms of giving voice to billions of people around the world, and further noted that the exercise of freedom of expression may be subject to limited restrictions which are prescribed by law and are necessary, for example, for the prevention of crime and protection of fundamental rights of others, but stressed that any such restrictions must be balanced and comply with international law on the right to freedom of expression. However, while the internet and other technologies offer enormous opportunities, they also present new challenges, particularly with regards to the protection of human rights. Regarding the Southern African region, it has been observed that the sub-Saharan Africa has the highest growth in global internet penetration, increasing from less than 1% in 2000 to 30% today. This finding is also true for all the nations in Southern Africa specifically. Whereas the region has undoubtedly seen advancement, this development is not without challenges. For example, laws exist throughout Southern Africa, which require surveillance through mandatory installation of state equipment on ISP infrastructure and interception with or without a warrant. Examples include the Interception of Communications Act in Zimbabwe, the compliance, monitoring, and revenue assurance regulations in Lesotho, the Electronic Communications and Transaction Act in Zambia, and the Telecommunications Act in Mozambique. Section 205 of the Criminal Procedure and Evidence Act in South Africa. Furthermore, increasingly, there are reports of interception of communications arising using enhanced surveillance technology. For example, a number of Southern African states reportedly use Circles, a surveillance platform which exploits telecoms system to access telephone calls, SMS messages, and location services. And some Southern African states have been named as users of Pegasus, a military-grade spyware which gains full access to any subject's mobile phone. Such actions go against the principles which are contained in the Declaration. Specifically, the Declaration provides for a right to privacy, including the confidentiality of communications and the protection of personal information. That is in Principle 40. And further, the states that shall not engage in and condone acts of indiscriminate and untargeted collection, storage, analysis, or sharing of a person's communication in Principle 41. The Declaration also specifies that any law that authorizing targeted communication surveillance should provide adequate safeguards for right to privacy, and most importantly, that states should adopt laws for the protection of personal information of individuals in accordance with international human rights and standards. That is in Principle 42. I would like to encourage all the participants in this event to utilize the revised declaration in order to ensure the promotion and protection of Article 9 of the African Charter in general and digital rights in particular. The declaration can be accessed on the Commission's website in the 4 AU languages. The report being launched today, The Digital Rights Landscape in Southern Africa, provides a useful study on the African Charter and other international and regional human rights instruments which are relevant in articulating human rights in the present digital age. The report aims to contribute to existing works on the status of digital rights in Southern Africa and to act as a resource for civil society actors, public officials, regulatory bodies, and media organizations in the region. This report is invaluable not only for Southern Africa, but for the rest of the African continent, as it provides an important point for self-reflection on how to enhance the concept of digital rights. I am confident that this report will contribute to and further enhance the promotion and protection of digital rights in Southern Africa. I look forward to working with the Center for Human Rights and all participants in this program to achieve this laudable goal. Thank you for your kind attention.
Thank you very much, Commissioner. I'm sure some of you had not engaged with the new Special Rapporteur on Freedom of Expression and Access to Information. So now you know who the mandate holder is and what she stands for, and she's ready to work with stakeholders in advancing digital rights on the continent. Let's liaise with the African Commission. Let's collaborate with the African Commission and advance these rights, and indeed make use of the Declaration of Principles on Freedom of Expression and Access to Information. In Africa, it's a very progressive instrument that really requires all our efforts in advocacy and other areas, and we can make use of it the best way we can from where we sit. Now we move on to the next segment. I would like to call upon my co-moderator, Maristella Simiyu. Thank you.
Thank you very much, Klengiwe Dube, and thank you very much, the Special Rapporteur, for the words and for being here with us today. As Klengiwe mentioned, my name is Maristella Simiyu. I work as a programs officer with the Expression, Information and Digital Rights Unit at the Center for Human Rights, University of Pretoria. Let me first start by just thanking everyone for joining us today. For this labor that led to this report that we are launching today. We have actually worked tirelessly in the development of this particular report, which has manifested today. And you can see that we believe, and when you go through the report finally, we hope that it will indeed be a resource for media, regulators, for policy and government, for academics, for people in civil society organizations, when they're assessing the status of digital rights in Southern Africa and finding where they situate themselves in terms of advocacy for digital rights in Southern Africa in a way that is in compliance with international laws and standards. So we really hope that this report will be helpful to everyone who engages with it. As I've introduced, this report was in fact, yes, conceptualized and developed by the Expression Unit. And as has been mentioned before, it was drafted by Alt Advisory. Just to give you a brief of a background about Alt Advisory, it is a public interest advisory and research firm that is based in South Africa, which questions convention and works for positive change in Africa and the world. It assists socially responsible organizations with advisory and analysis, research, impact, training and communications, and design services in the areas of public law and policy, information rights, data privacy, and emerging technologies and innovation. So just anyone who would want to engage Alt Advisory in the future, you can see which areas that they specialize in, and having read this report, you can be assured that they will deliver excellently when it comes to such drafts. Alt Advisory today is represented by Slindile Khumalo, who was one of the drafters for this report. She's an attorney of the High Court of South Africa and a researcher at Alt Advisory. Her background is in commercial litigation, dispute resolution, and public law. Slindile is also currently an associate at Power C Incorporated. Her work largely focuses on public law and international law matters. She's particularly interested in contributing to the protection of women and children, both offline and online, as well as understanding and improving the quality of education policy in South Africa. So largely to the gist of this event today, I am going to invite Slindile Khumalo to make a brief presentation about this report, and we'll engage a bit on it before we go to the next session. Welcome, Slindile.
Thank you so much, Mary Stella. And I must start off by greeting everyone on the call. It's such a pleasure to be a part of this very exciting launch of the report. Thank you for having me and inviting me. I'm joining the call this morning from a frosty Johannesburg. I won't go into, the background of ALT. Thank you, Mary Stella. You did a fantastic job. As Hlengiwe mentioned a few months ago, ALT Advisory was approached by the Centre to prepare a report identifying, the trends, gaps, and challenges and developments as well pertaining to digital rights in SADC. We've had the pleasure of, engaging with CHR on previous projects, so we were really enthusiastic to be joining them on this particular project. We wanted the report to be accessible to everyone online and offline, hopefully, but we wanted it to be particularly useful to stakeholders involved in the realization of digital rights and to help guide them of the progress, made in SADC thus far and some of the gaps that they could perhaps pay particular attention to. I think the importance of undertaking this research was succinctly phrased by the former United Nations Special Rapporteur on the Right to Privacy, Joseph Canotsi, who rightly pointed out, and I quote, "The tripod of enabling rights, privacy, freedom of expression, and freedom of access to information existed before the advent of digital technologies. So did the right to dignity and the free and unhindered development of one's personality. Digital technology has, however, resulted in a huge impact on these rights, both offline and online," close quote. In terms of the report's structure, it looks at 6 major sub-themes which relate to digital rights. These themes are internet access, privacy and data protection, the regulation of emerging technologies, restrictions on freedom of expression, media freedom and regulation, meaningful inclusion and equality in the digital environment as well. More specifically, with the last sub-theme, we look at considerations, as Hlengiwe mentioned earlier, for children, women and girls, and persons with disabilities, as they may face specific challenges when it comes to their exposure to ICTs and exercising their rights in the cyberspace. So I will take everyone through 1 or 2 salient points under each sub-theme in a moment. But before I do that, it may be useful to point out that the meat of the report, I believe, has to be the recommendations that we've crafted to various stakeholders, which we've tried to make as comprehensive and as meaningful as possible with the CHR team. It's also perhaps important to note that the report builds on existing work and it highlights relevant provisions throughout of instruments that we do have in the region, particularly the Malabo Convention, which is fully known as the Convention on Cybersecurity and Personal Data Protection and was adopted in 2014, as well as the African Commission on Human and People's Rights 2019 Declaration of Principles and Freedom of Expression and Access to Information in Africa, as discussed by the Special Rapporteur. It's probably also useful at this point to highlight, as has been mentioned earlier on this call, that the African Charter doesn't explicitly grant internet rights or the right to internet, but Article 9 is relevant for our present purposes. Article 9, of course, protects every individual's rights to receive information as well as express and disseminate an opinion. And of course, we know that in today's climate, this right is often exercised in online spaces. We also know that on more than one occasion, the United Nations has affirmed that the same rights people hold offline must be enjoyed and protected online as well. Back to the sub-themes and some of the major findings that we made in drafting this report. Overall, as is the case with other relevant topics and subjects that are necessary to understand the realization of the provisions of the African Charter and other instruments, the data and information around digital rights in SADC is scattered all across the internet, and at times it's unclear why this is, why there are gaps, or whether the information before you speaks to the reality on the ground and is the most up-to-date information. Nevertheless, we were able to collate the information that we've kind of plugged into this report through a comprehensive literature review and review of regional and domestic instruments and laws. When it comes to the first sub-theme, being internet access, we try to dissect the components that are necessary for meaningful access. So it's not very useful if someone has access to the internet, but a supply to electricity in their neighborhood, for example, is unstable, or the infrastructure is not maintained properly. Those of us based in South Africa know all too well of the woes of Eskom recently, which has implemented load shedding since 2008. I was reflecting on how long this time has been earlier on today, and I was in grade 7 when load shedding was first implemented. I'm 26 now, so it really has been a long period of scheduled power outages. For those of us who may be based in Zimbabwe, regular power outages by ZESA have also unfortunately been normalized over the years. Beyond supply to electricity, we have to look at other components. For example, data costs. It's not very useful to individuals if costs are excessive or disproportionate to the income that they may earn. We often found that even outside these different components, the internet penetration rate itself is still comparatively low in SADC, with most states falling far below the 50% mark in terms of members of the population who are connected online. Moving on to the second sub-theme, I beg your pardon, which is privacy and data protection. The Malabo Convention, which hasn't kicked in yet because not enough states have ratified it, requires states to enact domestic data protection frameworks. It's encouraging that there has been broadly a positive trend in enacting such laws, despite, the slow progress in ratifying the Malabo Convention. Given the relative newness of these laws, most of the region is still testing out whether their data protection mechanisms work and are practical, what enforcement looks like. And of course, we expect the judiciary in time to create or develop jurisprudence that will guide stakeholders. When we speak of emerging technologies in this report, this refers to developments and innovations relating to artificial intelligence, biometric technology, surveillance technology, and robotics. These concepts sometimes seem or sound foreign, but for example, during the pandemic with the use of contact tracing apps for COVID, we probably have engaged with them more frequently than we realize. Mandatory SIM card registration is still a trend throughout the region, and there still appears to be a large-scale collection of biometric data, and we're trying to understand and codify the ethics of these technologies. On restrictions and freedom of expression and media freedom and regulation, international law narrowly prescribes, the circumstances under which freedom of expression can be limited. In the main, speech is not absolute, as we know, and may be restricted where it incites violence or harm or disseminates hate. What's critical when we look at the restriction of freedom of expression is abiding by the principles of legality, legitimacy, necessity, and proportionality. We have seen a couple of states in the region restrict speech beyond these principles. And we've seen, internet shutdowns, particularly during election time or times of high political tension, are not unusual, but this isn't specific to SADC. We know, the shutdown of Twitter in Nigeria last year has recently been ruled unlawful by the judiciary. Content moderation may also be misused by states through private sector providers, which speaks to the relationship between, the state and internet intermediaries. All in all, particularly when it comes to members of the media, the report highlights the need for these rights to be upheld with as little interference as possible. The last sub-theme pertains to meaningful inclusion and equality in the digital environment, and it explores how different demographics, specifically women, children, and persons with disabilities, must be protected by virtue of the specific harms they may encounter as they exercise their digital rights. We appreciate the importance of intersectionality and the need for nuanced support when it comes to certain groups. With children, they may be exposed, of course, to the internet and everything that comes with it from a very early stage of their lives, but it's important to ensure that the content they're exposed to is appropriate and is not harmful to their evolving capacities, and that their data is not exploited. When it comes to women and girls and persons with disabilities, what we observed was a trend of a lack of access, which means from the onset that these groups in particular are comparatively excluded from the cyberspace. I'm going to move on to the recommendations, which, as I mentioned before, really are the highlights, I believe, of the report. And I don't want to spoil the experience of reading the full report once it's available, but I will certainly give everyone a sneak peek and touch on some of my favorites. So I've boiled them down to 3, which, of course, the report contains many more recommendations to various stakeholders. But we, for example, recommend that the Malabo Convention must not only be ratified by all states and brought into operation, but that given the time that it's lapsed since its development, the convention should be updated. As I mentioned, it was crafted or adopted in 2014. So, lots of advancements have been made since that time. We also recommend transparency in public and private partnerships with rigorous public participation to improve access to the internet and electricity and other components for meaningful access. We further recommend and welcome the use of strategic litigation when it comes to privacy and freedom of expression violations, internet shutdowns, challenging the silencing of activists and members of the media. And we see a role for the courts to play in drawing a line in the sand on these issues. So in closing, while progress has been made, there's definitely action required from different parties to ensure that the region can properly enjoy the fruits that come with sound digital rights governance. Of course, we all want the continent to thrive, and for states, policymakers, civil society, and the private sector to stay on top of these issues for the benefit of all. I'm looking forward to engaging with the participants on this call and just having a chat around, some questions that have to do with the sub-themes or anything else that may come to mind. Thank you so much. I'll hand back to you, Mary Stella.
Thank you very much, Lindile, for that brief but very actually quite comprehensive sort of overview of the report. And I think just touching on some of the sub-themes that you've mentioned, it at least provides our attendees with an idea of what they'll sample, what they will engage with when they work with this particular report, when they finally read this particular report. As you've indicated, today is a bit of a soft launch, and come Friday or soon, even next week, we should be able to make the full report accessible to everyone. And of course, just to pick up some of the things that Slindile has mentioned in her presentation, if you look at some progresses that she's made, that the continent, the sub-region has made in terms of, for example, laws that have been coming up. When we look at issues of cyber laws and data protection laws, those are some of the developments we've seen as we've developed this report, and that Slindile has talked about. And one of the objectives we had in the development of this report is in terms of how CSOs and other stakeholders can find points of entry or further points of engagement when it comes to digital rights. And again, going through this report, it should be able to provide the reader and anyone interested, any stakeholder, with an idea of what point of engagement or where to start off, because as we have said, we are contributing to already existing works. Something else that I would actually put to Slindile to talk a bit about is in terms of developing jurisprudence in this area, because in the research you did identify one of the progress in this field is developing jurisprudence. Are you able to speak about South Africa, for example, in terms of developing jurisprudence, something interesting around SLAPP suits? I'll put you, Slindile, on the spot a bit here.
Yes, thank you so much for raising that. So for those on the call who may not be familiar with SLAP suits, a SLAP suit is strategic litigation against public participation. And we've seen this type of lawsuit being recognized, in terms of foreign law. And we've recently seen that it is made its way into South Africa. In February this year, the Constitutional Court heard its first SLAP suit matter. And the matter, just broadly speaking, has to do with a bunch of academics and environmental activists who had shared or made remarks about a mining company in different capacities. The mining company, as we know, is very well resourced and powerful, then instituted legal proceedings against the academics and activists, who then raised the defense that the claim brought against them constitutes a SLAP suit. So should the court accept this, it will be the first time in South African jurisprudence that the SLAP suit defense is recognized. These suits are often launched for astronomical amounts that private individuals can't afford to pay, and they really are a way to intimidate and silence dissent or opinions that may not sit well with more powerful bodies. So that is something we're really looking forward to as the Constitutional Court handing down judgment. The case is the Mineral Sands Resources case. And that's just an example of where the region is going in terms of understanding how freedom of expression is restricted in many different forms.
Thank you, Slindile, for that. And it's indeed, I think as all stakeholders, we will be waiting for that, because however it goes, it will be a landmark judgment in the African continent. It's something that has been developing a bit in the global north in respect to freedom of expression and its implications. And so it will be interesting to see how the Constitutional Court in South Africa decides in this regard, and what platform it will be setting in terms of jurisprudence in Africa. Just to pick on some of the challenges that Slindile spoke about when giving the overview of this report. She talked about network disruptions that we have been seeing, not only but in the African continent and beyond, that have grave implications on the exercise of digital rights. She spoke of some government perpetrated actions against freedom of expression and how we exercise our freedom of assembly and association, issues on attacks on the media, issues of poor governance, for example, when it comes to the laws, which is linked now to the recommendation against policy reform and legal reform. And an interesting challenge that was identified in this particular rights is the issue of digital divide, which with the COVID-19 pandemic that we could be possibly finding a way to live with it or just slowly emerging from the COVID-19 pandemic, it did bring about interesting dynamics in terms of digital rights. And I will just ask you, Slindile, again to talk about how the COVID-19 pandemic gave us some insight in terms of digital divide and how we exercise digital rights. Slindile.
Yeah, of course. Thank you, Mary Stella. So, of course, the digital divide is not a new concept. It's something that's been thoroughly researched and written about before. And we just wanted to identify where the progress has been made in SADC specifically. Maybe to start off on a positive note, when it comes to the gender digital divide specifically, we noted 4 countries, or 3 countries rather, Mauritius, Namibia, and South Africa, who in recent years have been reported as the fastest to kind of close the gender digital divide, which is really encouraging, even though there is some progress to make still. And I think, as Mary Stella rightly pointed out, COVID, meant that people spent a lot more time on their screens at home, and they had to rely on ICTs to kind of just carry on with their lives, from working to being educated, to even simple things that we take for granted, such as online shopping, getting groceries delivered. So we really saw, lack of access disrupt the way that people could carry on, given the movement restrictions that were in place, particularly the more harsh ones. I know in South Africa, we went up to alert level 5. But yeah, it's really highlighted just how much people rely on the internet to realize their rights to education, to access critical information about healthcare, and the like.
Thank you for that. And maybe just something else. We know that freedom of expression is one of the anchoring rights, especially when we're looking at these reports and developing this research. And one of the themes that came about, of course, since we keep saying the rights that we exercise online are the same as we exercise offline. And so there's that linkage when it comes to these 2 dimensions. And the media that has developed quite significantly during this period in this digital space. There are different implications that we see when it comes to digital rights and the media space. Are you able to speak a bit about the findings around how media freedom has been evolving in the context of the digital space and the implications of digital rights, specifically when you look at media and the broadened definition of media?
Of course, thank you. I think, it's a given that the way that the media reports has been changed by largely social media and the instant nature of sharing information as it happens in real time. And one thing that we focused on in the report was network throttling, which is the intentional slowing down of internet connectivity or speed to stop the free flow of information. And of course, internet shutdowns. I cited, an example falling out of SADC, which was the shutdown of Twitter in Nigeria last year. We've also seen a few examples of internet shutdowns in Zimbabwe, particularly during times of protest, where the government had actually warned people that if they participated in the protests, they would be considered as having participated in an insurrection, and the kind of social media shutdown being implemented after these warnings. So we've seen really during times of criticism of the state or public bodies, we've seen the states actually influence private actors who support in enabling the right to internet access, and just, the power dynamics there have obviously been used, sometimes in harmful ways. And it's really important that the media is able to report on this, not only to the people who may be impacted, but to potentially seek support outside of, wherever they may be placed. So yeah, it's something we've tried to highlight in the report, and hopefully in time we'll see the trend dying down.
Great. I guess something else interesting, I believe now, for some of us who've read the reports and have a snippet of what is in there, is in terms of how we see developing laws in the African context, in the context of digital rights, which on one hand is progressive when you see emerging cyber crime laws, emerging cyber security laws, emerging laws on data protection. Mm-hmm. And then one thing else we did with this report is frame it, these digital rights in the context of Southern African, but in the broader umbrella of the international landscape when it comes to freedom of expression, access to information, and data protection. So just maybe a brief, what do you feel in terms of the findings of how the emerging laws compare or are in compliance with international law and standards in this regard?
I think we've seen developments recently in terms of understanding the importance of privacy rights, freedom of expression and association online. So the fact that there's recognition on a regional level and at a domestic level for most states is wonderful. I do think there are gaps in some of the laws that have been created thus far. And one gap which we identified and discussed in the report was sometimes we found that there was a lack of judicial oversight for different, like the interception of communications, which of course speaks to, freedom of expression and privacy rights and all that. And we also found that sometimes data protection authorities weren't properly capacitated or well-resourced, or haven't yet actually started carrying out their mandate because the laws are still in progress and haven't actually kicked in yet. So while, we have, if I can put it this way, while we have the laws on paper, we still need to see them being translated into kind of practical, tangible ways to ensure that rights violations are prevented entirely.
Thank you very much, Lindile, for that. You've raised something quite important there about oversight mechanisms, about implementation, and it could be another entry point for civil society organization when towards engaging with oversight mechanisms to ensure that in whatever way they're exercising their mandate is actually in compliance with the standards, the correct international laws and standards. Thank you very much, Lindile, for that. I had hoped in the meantime that we'll have some questions in the chat box. I don't see any apart from Frederico, who is one of our speakers, who's asked when the report will be made public. The final version of the report should be available on 15th August 2022 this year, and we are going to have it publicly available on the website of the Center for Human Rights, and I'm sure Alt Advisory will also publish this report on their website. We'll be happy to share it once we have the final reports, but we did give you during the presentation a snippet of the report, a snapshot of the report and what it covers. And I can assure you it is quite comprehensive and it will be an interesting resource for all stakeholders to engage with. With that, I am going to hand over the baton to my co-moderator, Tlengiwe Dube, to take us through the next session. Thank you very much, Lindile, and over to you, Tlengiwe.
Thank you so much, Mary Stella and Slindile for that session. So there is our report, which is an overview of the landscape of digital rights in Southern Africa. And I think there's been a mix-up of dates. We are going to have our first training session that is based on the report on the 15th of August. But by then, the report will be publicly available, hopefully on Friday, this particular Friday, not the 15th. By the 15th, the report will already be there, but we'll be starting our trainings that are based on the report. Now we are moving on to a session which is very close to my heart, and it's something that is also mentioned quite extensively in the report. And that is the issue of surveillance. And state surveillance is becoming very topical when we're discussing issues around digital rights. And we have brought two experts to have a very interesting conversation around that area. And I just want us to zero in on how this is playing out in Southern Africa and also the impact on human rights, not only in Southern Africa, but generally on the continent. And to help me in this discussion, I have two speakers, Ms. Heidi Swart, and she's a South African freelance investigative journalist, and she writes about espionage, security, surveillance, privacy, and then she looks at these subjects both within the private sector and the public sector. And she has also written quite extensively about illegal surveillance, interception technologies themselves, artificial intelligence, biometrics, and also just bringing the conversation into the COVID-19 context as well. And together with her, we had Frederico Links. And Frederico is a Namibian journalist, and he's also a researcher. He's also at the same time a freedom of expression advocate. And as a researcher, he's affiliated with a think tank in Namibia called the Institute for Public Policy Research. And in that institution, he coordinates a number of projects. So in both his journalism and research, he has very strong focus on good governance, human rights, which also includes digital rights, obviously. And then he also looks at issues around corruption, rule of law, transparency, and accountability. And at the moment, he's coordinating a project on mainstreaming human rights in cyber crime law and policy making. This is being done in collaboration with global partners, Judicial. And he's also the coordinator of the Democracy Report Project at the Institute for Public Policy Research. And I think the research was launched recently, and those are some of the works that Federico is doing in Namibia. And you know, part of this exercise is also to showcase some of the work that is being done by colleagues and other institutions, and this is part of the work. We'll put the full profiles on the chat box, so that if you want to engage with these colleagues, you can also just engage with them directly, and you can look at their profiles. So indeed, the subject of surveillance, Heidi, is very topical, and I just want you to give us a brief background of the work that you have been doing within South Africa on surveillance.
Hi, Sandila. Thank you so much for having me. I'll try to keep it brief. So for the past 8 years, 7-8 years, I've been looking at various forms of surveillance in South Africa, but with an emphasis really on law enforcement and security. A very important component of my work is looking at the technology that's being used to spy on people's electronic conversations and digital conversations. Data gathering programs that allow governments to scour social media, the installation of spyware on networks, and the role of international telecommunications companies in keeping our communications secure, as well as the law the laws that are supposed to protect us but don't. I have a presentation. I'm not sure if you want to see the whole thing, but I can also just talk about my most recent work, which I think will perhaps be more relevant for this discussion, and that concerns the laws in our country that protect us from that are supposed to protect us from espionage, and not just state espionage, but also to an extent corporate data gathering as well. So our main law is the Regulation of Interceptions Act. That's the RICA Act for short. It's actually the Regulation of Interception and Provision of Communications-related Information Act. It's a whole long thing. And so what it does is, it was originally brought in after apartheid ended, because suddenly telecommunications were privatized. Before, during apartheid, the government could easily spy, and I think it was commonly known, they could spy on the telephone networks because they owned the telephone networks. And they knew exactly who was making which calls, because it was obviously on a landline going to someone's house, and the phone was registered in somebody's name. So then what happened was, as the new governments came in, so did MTN and Vodacom and the cell phones. So now suddenly anybody could own a phone. It didn't have to be tied to your name. And also they had no way of intercepting any communications on the private networks. And that's why they made this law. And it forced telecommunication service providers to install equipment and technology on their network that would allow the police to listen in or record conversations if they had a warrant to present to, special court warrant from a special RICA judge that they could present to the operators like Vodacom and so on. So it also allowed, secondly, the police and the state intelligence services to force service providers to hand over your metadata, which is the call data records, who you phoned, when you phoned, and your approximate location. And as technology is advanced, that has of course become much more sophisticated. In at least theoretically, there's now a lot more metadata being generated, and technically, in terms of both RICA and our Cyber Crimes Act, it is now possible for law enforcement to get your cell phone downloaded and obtain a lot of information, including metadata and including communications on that. So anyway, so that's RICA. And the third thing that RICA did, before I forget, is it forced us all to register our names when we purchase a cell phone. And the point of that was to supposedly be able to track someone down. So if you purchased a cell phone and a SIM card and you were stupid enough to provide your name and address, and you were a criminal, then the theory was that they would then be able to track you down. And of course, that's backfired because there's no secure, efficient way to ensure that people provide legitimate information when they RICA their SIM cards. So as it's come to be called. So what happens is people can provide false information, and most of the time people in the security industry will tell you that this information is useless in tracking down criminals. So either it belongs to a deceased person, or it'll be some elderly person in a small town somewhere that's never even used a cell phone, that type of thing. So there's a lot of fraud going on there. So those are the laws. And of course, these have been open to abuse. And the trouble goes both ways. It's possible to, our special RICA judge has no real way to verify whether or not the information that's put in front of him or her is in actual fact reliable. Police can, do an affidavit if they have an informant making a statement. Usually that's enough. Of course, the crime has to be serious enough, and you still have to at least convince the judge. But again, the judge really doesn't actually know what's going on. And that was one of the issues that was raised during a recent constitutional court. And maybe this is the most important thing about RICA that's happened recently. I know Alt Advisory was involved there as well, is that investigative unit Amabongani and their veteran reporter Sam Sol, they won a case against the government to make constitutional changes to RICA. And that would be changing for example, the judge has to be independent by someone who is, has to be appointed by someone who's independent, and not by, for example, the Minister of Justice, who might make it a political appointment, which is what's happening now. Other things is that they now, if they've intercepted your information or they've drawn your call records, they have to let you know within a reasonable amount of time. Obviously, that they can't jeopardize the case with it, so there are exceptions. But there is a time limit to how long they can carry on without letting you know that you've been intercepted. And that then will theoretically allow you to question why that has happened. There's also special protections for journalists and lawyers and their confidentiality that's supposed to be built into the act when it is changed now. All of that is very important, and it was hailed as a victory, and it's a huge step forward. But I also think that given the technology that's available, we're going to have a very difficult time really implementing it, because we have things like Pegasus now, we have things like circles, we have spyware, which really is a whole different ballgame. Really, now that cyber espionage has entered the interception arena. That said, there are also major issues with the state's ability to intercept. There have been multiple reports that their technology is outdated. They can't decrypt data. and their cyber abilities are waning because they are losing skilled personnel due to retirement or people leaving and going into the private sector. It's causing a major problem both for our cyber abilities and our interception capabilities. Again, there's very social media to make sense of call data records that were, which can get very, very complicated if you really must analyze it to find the relationships. But the use of that technology is limited, both because there's a lack of political will to purchase it. So people have told me that our government doesn't really want to get the fancy stuff because they're scared it's going to be used against them. It's another weapon that can be used against them politically. And of course, there's the issue of the skills shortage. And then finally, I think perhaps our biggest problem in South Africa, at least, is our commitment to, well, our security services commitment really to secrecy and swearing everything to secrecy, including their budget. We don't know what they do with their budget. And this practice of keeping all that they do and all their interception, under wraps and their operations under wraps and their lack of reporting to the public is not it's not a South African problem even, and it's not an African. That's not where it originated. It originated in the West with the Central Intelligence Agency of the United States and MI5 in Britain. Much of intelligence services, and I'm not even talking about the security services. I'm not talking about the police now and legitimate police investigations into criminality. I'm talking about our domestic intelligence services, the spy stuff, the James Bond stuff. Much of that activity, while it started as being being carried out for national security, although there may be truth in that, we don't really know. I would surmise that much of that also has to do with promoting national interest. And national interest can be something that is defined solely as keeping political parties that are in power. And to protect the national interest, very often interception is used and the espionage mechanisms are used to, in fact, keep an eye on the public, keep an eye on dissidents, and keep an eye on anything that could threaten those in power. And of course, it's used outside of the country to the detriment of other countries in the interest of the country conducting the espionage. So that's national interest. National interest really is turning the enemy into, under the guise of national interest, I'm going to say, political interests are protected from the local population and also by exploiting the foreign intelligence services. So all of our changes to our interception laws are in a manner undermined by that constitutional institutional culture, which we very much inherited from Western countries, sadly inherited from Western countries. And yeah, so that's our law as far as interception is concerned in a nutshell. We have major challenges and we have not only tweaks or changes to the law, although they're extremely significant. We still have a long way to go in changing institutional culture. And I mean, it's as old as the mountains, right? It's like one of the oldest professions, espionage, and sabotaging your voters, sabotaging your local population whose interests you're supposed to protect in order to protect your own political interests. So yeah, it's part of a much bigger story. And we're nowhere near finished with our battle for human rights in this regard.
Thank you so much, Heidi. It's quite comprehensive. You touch on a number of issues. It's the legal framework, it's the technologies that we see being adopted right now, it's the oversight mechanism. It's a whole lot of issues. I want to move on to now to Frederico. You are a journalist, you are an investigative journalist, you are a researcher, and you are also a freedom of expression advocate. And the issues that Heidi raises in the context of South Africa, how does it play out in Namibia? For example, are journalists facing the same challenges? Like if you see the South African case, it was brought before the courts because of the surveillance on journalists. And I just want to, you to comment on the Namibian situation and also zero in specifically on journalists.
Thank you for that, Lingiwe. Can everybody hear me fine? I've had a bit of a flu over the last few days, so my voice is a bit raspy.
It's okay.
All right, thank you. So yes, I mean, the issues there are issues that I think in some aspects play out across the region. I mean, if you look at what's happening in some and what happened under the Lungu government in Zambia, the move towards greater, sort of state control of cyberspace. What happened in Eswatini last year with the 2 internet shutdowns that they were orchestrated there in the national interest and maintaining public order, and what's continuing to happen in these countries. In the Namibian context, of course, Namibia is always held up as a good example of where things haven't gotten as bad as they might have gotten in some of our neighbors. But I mean, we're sort of slowly heading there. We have a situation where some of the things that have been found unconstitutional in South Africa under RICA are now being introduced here. We have regulations under the Communications Act of 2009 that come into effect on the 1st of January next year. And these regulations, just when I have to speak, my nose starts acting up. Sorry about that. We have these regulations, and they are mandatory SIM card registration and data retention regulations. So what this basically means that, I mean, and where sort of RICA touches us, and what's happened under RICA and the court judgment, and they were specifically here waiting for the judgment, because they had crafted these regulations before. I think the RICA judgment came out early last year, and they held them back to see what the judgment would be, and when the judgment came out, and they realized that some of the things that they had proposed, and I shudder to think what they could have been. They held them back, and they reworked the regulations. But the reworked regulations, still make provision for blanket data retention, which is basically mass surveillance. And we already have an opinion, a legal opinion on this, which from one of our associates, the Legal Assistance Center here, which did an analysis of these regulations and found that they could become constitutionally problematic or unconstitutional. And this is something that we've been warning about. And to the area where we are especially concerned with, you address the issue there of journalists, is that unlike what the Constitutional Court in South Africa found or ruled, there is no carve out in the regulations for journalists. and for lawyers. And already these two sectors have, started talking about this and are talking about this. And I think in the journalistic sector, we're still sort of casting around for how do we respond to this. I know that in the legal sector, there are discussions ongoing around this, but nothing has sort of emerged yet. Sort of a firm stance on this. But I do suspect we'll see that towards the end of the year, later in the year. But these regulations are now a serious concern and have become a serious concern. And I was 2 weeks ago, I was doing 2 presentations at an event. And when I explained the extent of the data retention and SIM card registration, the sort of information they would be collecting and how they could use that information to pinpoint anybody, the location of anybody, people were sitting shocked. They were saying, some people, especially young women in the audience, they were saying this is going to force them to reduce their internet usage, their phone usage. And this is exactly the sort of thing that organizations like Privacy International have warned against in other parts of the world and on the continent where these sorts of SIM card registration, data retention regulations have been introduced, how it has, in some sense, discouraged internet use. And this could be something that could play out in Namibia as well, judging by, just the responses I got from these presentations 2 Saturdays ago. So, I mean, the concerns are huge. And of course, I mean, we are addressing, I'm writing articles about this, and one that will be published on Friday, this coming Friday in the Namibian newspaper, the big newspaper in Namibia, on this issue of, just how invasive the new regulations will be. They were actually gazetted on the 28th of April this year. And the Communications Regulatory Authority of Namibia is now on this roadshow. And they've got this mascot called Simi. Simi, and in this roadshow, Simi is a SIM card with legs and arms and smiling. And Simi is preaching this message of how this is about your security and your safety online and so on. So they're telling the good news story. And today they're having this big this afternoon they're having this big similar discussion like this, but on the national broadcaster panel discussion on these the mandatory SIM card registration and data retention regulations, because there's been pushback. And the pushback hasn't been what they thought it would be. They thought people would just accept it, but people are not responding positively to what they're saying and how they're trying to frame these regulations as in your interest, in the public interest. In people realize that there's a problem, and that this could be a problem, that the surveillance that this enables, the mass surveillance these regulations enable. People, I think, innately realize that this is something that threatens their human rights and their ability to communicate openly and honestly, and could affect the politics of this country. So these are issues that are playing out here, and they are similar, of course, to what's playing out in the neighboring countries. I mean, in Botswana, the issue of both circles and Pegasus being used on civil society and journalists in that country is a massive concern. So I mean, these are trends that aren't positive. And the other aspect that we have to look at is the sort of cybercrime laws that our governments are making and implementing. We're trying to keep them sort of on the best practice side, but you can see how they are listening to the bureaucratic sector, the military and the national intelligence and secret services for most of the guidance, and they're not being really consultative processes in these cybersecurity related law and policy making. So, I mean, the trends are concerning, and it speaks to the deterioration of civic spaces online, both online and offline, the deterioration of democracy, both online and offline, and how people view the internet these days, and their communications these days. People have become a lot more suspicious, and I mean, and it's because of sort of the things that they are encountering, and the things states are doing, and as well as the practices of non-state actors such as corporations. So we can discuss it further from there.
Thank you. Yes, that's the Namibian context, and also you were touching on Botswana, and I like the reference that you are making also to this cybercrime laws that we see developing in Southern Africa, and we see that in some of the provisions they touch on issues of surveillance. And as I had mentioned, that we'll have this conversation also delving into the issue of human rights. Heidi, I just want you to touch on the human rights aspect, like the surveillance, unlawful surveillance. How does it impact our rights? What should we be wary of? To what extent is the human rights situation impacted when illegal surveillance is conducted on the public?
So one example, and this is a very, very practical example, is that the very first story that I wrote was about a man who used to work for crime intelligence and then ran into trouble with his ex-wife, who was still working at crime intelligence. And then she delved into his bank statements, his messages, his personal communications, etc. He had lodged a number of complaints, and out of desperation, he came to the newspaper and he spoke on the record in a national newspaper because there was no other recourse for him. So that's the one thing. It can really impact directly on you if someone decides to use it against you. The other also it's a very practical example is, we know that a few years ago, a detective, Charles Kinnear, was assassinated here in Cape Town. And the person who allegedly shot him was said to have tracked him with a very simple tracking technology where you simply input the person's cell phone number into the computer program, and it shows you the area where the person has moved and is moving currently, and not an exact location, but a reasonable estimate. And so the theory in the media was that this method was actually played a role in his death because his alleged killer was able to track him. So those are some very real potential and real dangers, sort of very real impact on human rights. But then there's also the issue of the Panopticon Effect. I think for me personally, I'm never comfortable ever with my communications. I am extremely paranoid that I am being listened to both on my and being spied upon, not only on my laptop, also on my cell phone. I don't do normal normal self-reports, it has to be on WhatsApp or Signal, something that's encrypted. But even so, I spoke to a security professional the other day. He said, well, you know, if you use Signal, the Israelis can listen in. If you use WhatsApp, the Americans can listen in. If you use Telegram, the Russians can listen in. So you take your pick. And we don't really know what South Africa's intelligence exchange arrangements are with these countries, whether these countries can actually intercept our encrypted communications and then relay the decrypted information to our intelligence services. We don't know. So constant anxiety really about whether or not your communications is private, and the underlying assumption really that it's not private, and you have no real privacy. I'm quite worried really when I talk to sources, especially if it's about politically sensitive issues. One tries to do it over encrypted communications. You try your best, but in the end, you have a feeling of hopelessness that if people really want to find you, they can. And South Africa has so far been relatively peaceful, I think, compared to other countries in Africa, but things are heating up for journalists here as well. So yes, I think a very real and concrete effect on human rights.
And Federico, in light of what Heidi has just mentioned, you know, the real fears, you know, when you're looking at surveillance, and she's talking about how paranoid she is. And I mean, she's, you know, you're never safe online. Somebody somehow is listening to you or watching you. I don't know whether we can say it's because of the work that she does, or that's the general feeling that the public has, is that the level of awareness that we have around surveillance. And how are people pushing back against surveillance? Are people taking up methods to ensure that they are not under the, you know, cloak of surveillance, or what is the situation?
I mean, I think people are only starting to awake to the reality now. So, you know, you don't have the sort of anti-surveillance movements here in our part of the world that you have in say, in more developed countries, where people have developed their own technologies and their own, you know, ways of circumventing or avoiding surveillance and so on. And where there are, you know, sort of established civil society organizations with resources that can assist in this regard. So it's busy happening here for us. And I mean, just I think for us, for the organization I work with a few months ago, the you know, the reality of this actually hit home. So a few months ago, the IPPR hosted a side event with Transparency International as an online event at a UN Human Rights Committee hearing, and the side event was you know, was the UNHCR was part of it. And the side event was about corruption in Namibia, and specifically, you know, the state's and other actors' responses and involvement in the big fish rot corruption scandal here. And you know, you could sign up. You know, it's like these events, this webinar, for instance, where you get a sign up. And you sign up, and then you get a link, or there was a poster put out that if you send an email to the info@IPPR address, you will get sent the link to the event. And the day or 2 days before the the event actually happened. The IPR's whole internet or email servers went down. People were sending emails and they were communicating and they were sending emails. The emails were going through and everything, but the IPR wasn't receiving those emails of people signing up. And when we contacted the service provider, Telecom Namibia, state-owned, the big state-owned telecoms company, they said they aren't doing anything, and there was a lot of back and forth. And at some point, somebody said, probably something they shouldn't have said. They said, "Look, your traffic is being quarantined somewhere else. It's being redirected from our servers and it's being quarantined somewhere else. So we don't know what's happening." So clearly there was interception of communications and of this internet, of this email communications, to see who was signing up, what was being said, and so on. And basically, I think to disrupt this event, to not have people attend the event. Who it was, we've never discovered. But you sort of suspect, this concerns the Namibian state. So, who could it possibly be? So yes, so I mean, these at it home, the IPRs realized, look, continue, but where do you go? All the other service providers are largely also state-owned or are affiliated to individuals who are close to the political elite here. So, your choices are limited, but people are waking up. People realize that there's a problem here. And I think that's part of the issue with our local news organizations here as well. They don't know how to respond at this point. There's been talk and so on, but how to respond to the emerging threat is something that that is something we're grasping and grappling with at this point in time still.
Heidi, when we look at the situation, that was unfolding in Mozambique, and now we are talking about terrorist attacks, not very far from where we are. And do you think that could be enough justification for the governments to up their game when it comes to surveillance? Because there's this imminent terrorist attack, and it's so close. If it's in Mozambique, it's within the region.
Look, I think they can definitely use interception in addressing that issue and trying to predict what terrorists will do. And organized crime, I mean, also much of the, speaking to some folks the other day in Cabo Delgado, is where a lot of weapons trafficking takes part there. It comes into the continent and also leaves the continent there. Okay, so those are part of well-established smuggling routes, and not just weapons, also drugs, etc. So they are fully justified in saying that they want to use that as a pretext for interception, but that would have to be overseen by a judge. It will have to be targeted. So here's the thing, and Frederica was talking about mass interception earlier. There is a tendency by governments to say, okay, let's use mass interception. We'll look at everyone's communications and see if we pick up a keyword here or there, just in case we find somebody who's guilty. And that is a dangerous pretext. And I'm not sure how effective it is, whether or not they're actually able to find people who are are dangerous by using sort of data analytics on masses of conversations. What I think would be, we don't know what their success rate is. That with that is, it all happens in the dark. Apparently, you know, most countries, or at least Western countries, have this capacity, but again, still terrorist events happen, and we're not sure. We don't know how many events they were able to prevent because of facilities of mass interception, right? So there's no way to see whether that is justified. On the other hand, they could use targeted interception, and this would have to be part of real police work and real intelligence and security work, where you infiltrate with your own agents and your own informants, where you infiltrate these networks, these smuggling networks, terrorist networks, etc., and then you know who to target, and then you make sure that you target those individuals and those groups, and perhaps people related to those groups. So yes, I think this can justify the use of it, but it doesn't justify the legitimate use of it. And we need to figure out, this is the other thing, we need to figure out how to do this stuff legitimately in a way that we can actually get people who are really committing crimes, make it doable for police and not restrict it so much that they have so many hoops to jump through that they actually can't do their work, but also provide enough oversight so that they don't just use these interception facilities in any which way they want to.
Thank you so much, Heidi. I like the fact that you bring out the complexities and, you know, addressing the issue around surveillance, and whether, you know, when you look at mass surveillance, can we completely say it's a big no, we can't do that? Or we can look at targeted surveillance, and we are also looking at the real threats that are facing states, whether it's organized crime, you know, and also specifically looking at the issue of terrorism. When we look at the guidance that we get from the African Commission on Human and People's Rights in terms of its declaration, it says states shall not condone or engage in indiscriminate and targeted surveillance. And in the same principle 41, it advises states to actually engage in targeted surveillance, and it lays out the parameters for targeted surveillance, which include prior authorization by an independent authority, which might be a judge, a due process safeguards should be in place, and post-surveillance notification, monitoring, post-surveillance notification, and all that. So that is the position that the African Commission has taken. And I think this is an ongoing conversation that we can have on and on. Just to mention that this is the subject that I'm also dealing with in my doctoral studies here at the Center for Human Rights, and you can imagine how frustrating it is to try and look at mass surveillance, and also look at targeted surveillance, and also stand from the perspective of the state, but also look from the perspective of a human rights advocate. So these are some of the challenges that we are grappling with when we are looking at surveillance, the surveillance situation, not only in Southern Africa, but also on the continent as well. And I just want to thank our speakers, Federico and Heidi. I just want to give you each of our speakers, Federico, a few moments to just say your parting words, and then we'll move on to Heidi, your parting words, and then Slindile again, your parting words as we wrap up. I'll start with you, Federico.
Thank you, Slingiwe. Yes, I think, you know, this is an area I think we will be talking about the digital rights space and digital rights in Southern Africa is an area that we'll be continuing talking about for years and years, because of what's happening in the law and policy making space, and because most of the trends are not positive trends, and and if you look at the framings of governments, we can all understand that surveillance is important in terms of as a cybercrime tool. But if you see how it's framed by politicians as a way to protect those in power, basically, to keep an eye on the youth, because that's where the threat for them comes from, is an unruly youth, a disrespect for elders. And this is the sort of language that we're seeing our politicians use when they talk about cybercrime and cybersecurity. They're not actually talking about actual criminal activity. And this is how you see things, if you look at what the comedians and bloggers that have been arrested in places like Tanzania, the journalists in Mozambique that have been covering the Cabo Delgado situation, it's actually being used against the people who aren't the threat. It's not being, you get the sense they're not in a situation to use it against the actual threats in society, but they're using it against the people who aren't the threats, the journalists, the youth activists, the social activists. So, and that's what makes, sort of the cybercrime and cybersecurity law and policymaking so distressing at this point in time in our part of the world, is the framing by politicians, and then the actual use of these laws and these regulations and these policies, how they're used against protesters and against writers and against journalists and against activists and so on. And you wonder, this is supposed to be a cybercrime tool, but it's being used in this way. And then the examples are many across the continent, not just in Southern Africa. So, we have to keep on spotlighting these issues, spotlighting the dangers as far and wide as we can across the region, in whatever manner we can, from whatever platforms we have, get people to wake up to the realities, and not just hand clap because, the politicians are saying we're doing this to protect you, because this is a big concern. Thank you very much for allowing me this platform today.
Thank you so much for taking time to share with us your experience and also your expertise around this area. I really agree with you that we should keep on spotlighting some of these issues. We haven't really started. There's a lot of work to be done. Over to you, Heidi.
Yes, so I fully agree with what Frederica just said. If you look at history, already in 1996, there was a journalist by the name of Nicky Hager. I think he was an Australian journalist, and he documented a global surveillance system by the name of Echelon, run by the United States, where they really did mass satellite communications interception of various forms of, it was emails, telephone calls, telexes at that time, everything. So already then these powers existed, and all of the technologies that people are talking about now, are noticing now for the first time, have been around for a very long time. And it shows you how slow the public is really to wake up to this. And I'm not sure why. I think in a sense it's because it sounds fantastical. Something like, I personally, I'd always known about Echelon, but in the back of my mind, it was a bit of a myth. And only in research that I've done now, again, that I see, oh, okay, no, this thing is real. And I think that's the thing, because it's so hidden and kept out of sight, and everything is so secretive that it's difficult for the public to see this as a concrete problem. It's much easier to just shove it to the back of your head. And also to think, well, it's not my problem. It has to do with journalists and lawyers and people who are really in the fray, nonprofits, etc. But we will have to spend a lot more effort to get the public to take notice of this. I think it is getting better, but also within the context of I mean, in South Africa specifically, we have a massive inequality problem. People really are suffering. And the last thing on their mind is being intercepted. That said, you have activists, community activists at the grassroots level who deal with the state security agency face to face. These people come to harass them. So it has a very real impact on our people. The trick would just be then to learn how to bring home the urgency of it, and to make it more public. And I think we need to start by campaigning so that governments around the world and companies around the world who sell this equipment have to be public about it. They have to disclose it. The European Union has just had an inquiry into Pegasus. In the 90s, they had a huge inquiry into Echelon. Why can't the African Union also start making inquiries and taking a stand on this? When things like this happen, when we hear about companies like Huawei siphoning off communications from the African Union headquarters, we hear about circles. I think African leaders need to come together and take responsibility for this publicly and take a stand on it publicly. And that needs to become the norm. Really, that needs to become the norm. We need our politicians to start showing the world, and we need to put pressure on them.
Thank you so much, Heidi. You bring in a wealth of experience and knowledge into this conversation, and thank you so much. I think we'll continue engaging in this particular area. Like we say, there's still a lot to be done, and you're raising a very important issue that there's a lot of suffering that is happening in society. There are a lot of inequalities, and the last thing that people are thinking is about their privacy or being intercepted. There are more serious or more immediate socio-economic challenges that people are facing, and that is taking their attention to these areas but also they're like kind of taking precedence over other issues or the particular subject that we are discussing today. And you also hear people saying that why I have nothing to hide, whatever, even if they intercept, there's nothing that they will find. So that is a very common sentiment among members of the public. And I think, like Federico said, we should continue spotlighting these issues so that people move away from that position of saying they have nothing to hide and give prominence to the right to privacy, which is a very important right, and also to hammer hard on the understanding that other rights are also anchored on your ability to enjoy your privacy, to enjoy your private space, and that is very important. So thank you so much, colleagues, for these interventions. It's been very useful. And I mean, Slindile, we've been together since February when this work started, and today the report is being launched. I mean, it's the tremendous work that you and your colleagues have done, and as the center, we really appreciate it. And I just want to give you a few moments so that you can say your parting words as we wrap up the session.
Thank you so much, Hlengiwe. I'll keep it brief because I think my co-panelists have done an amazing job at touching on a variety of issues. But one thing that I'd really like to see, and this speaks to Federico's earlier point about spotlighting the importance of these rights, is just data subjects not fully relying on different stakeholders to exercise and protect their rights. I'd really like to see a movement towards empowering people to inquire about what information is held about them, taking proactive steps and writing to data protection authorities to challenge the information that's held non-consensually. So I think there's definitely a part or a role for us as individuals to play in our little, little corners of our lives to understand and challenge the mass mass collection of our information and the violation of our right to privacy. Yeah. Thank you so much.
I'm glad that Lindile is smiling. I thought maybe at some point she'd end up hating me. You know, this writing exercise where it's a back and forth and all that. Thank you, Lindile, and I'm happy that you are smiling. And I see we have Roshni, and we mentioned that this report could not have happened without the support of our funders. Maybe, Roshni, do you want to just say a few words?
Thanks a lot, Shlingiwe. Good morning or good afternoon, colleagues. My name is Roshni Narundas, and I'm from the Advancing Rights in Southern Africa program, ARISA. The support of media freedoms and digital rights is one of our fundamental thematic areas. And as part of this work, we're also supporting work in Lesotho, Mozambique, Madagascar, and a couple of other places. We're also supporting work for gender links to do work on online gender-based violence. So we're really looking at how all these pieces of work come together collectively, and we're hoping probably sometime next year to actually bring all the players together and have an open discussion around this particular topic. So from ARISA, I really want to congratulate Alt Advisory and the Center for Human Rights, and thank you for doing this work. It looks exceptionally impressive. And I certainly hope that we will engage further with the report. Thanks to the Special Rapporteur. We appreciate your presence, as well as all the speakers, Frederico, Slindile, and Heidi, as well as the moderators. So thank you very much.
Thank you so much, Roshni, and it's been a pleasure having everyone, whether you're joining online, on the live streaming, we have this recording is on YouTube. It's also it will be available on our platforms. If you want to revisit or you want to share it with other stakeholders, you are free to do so. So going forward, the whole essence of having this research or this study was to create the basis for the next activities that we are going to have from 15 August up to the end of the year, where we are now targeting second stakeholders and doing targeted capacity building, because we will start off with the civil society organizations. We have a number of them in Southern Africa that we will engage in these particular areas that we have discussed, and some of them we didn't really extensively touch on, but they are there in the report. And we're also trying to target our parliamentarians, and we are seeing that, you know, with the framework that is developing, whether it's the cybercrime laws or you call them computer crime laws or any other term, data protection laws as well. It's very important to build the capacity of those lawmakers so that as they develop the laws in the region, they are compliant with international human rights laws and standards. And we are also targeting the policy makers as well. And also our national human rights institutions are a very important stakeholder when it comes to advancing digital rights in Southern Africa, and will be that's the work that we'll be doing going forward based on this particular report, because it's one thing to develop a report and launch it like this and speak about it, but it's very important to then take the next steps and make use of the report. And we also look further than the trainings and see how we can make use beyond these trainings. And I also want to encourage you as well to make use of the Declaration of Principles on Freedom of Expression and Access to Information. It's a very important instrument when you are looking at issues of digital rights on the continent. So it's been a pleasure, everyone. The Special Rapporteur was not able to stay throughout. The Commission is currently sitting for the private, the extraordinary session that is currently ongoing, but we'll continue to engage the Special Rapporteur, and also you are free to reach out to the African Commission and engage them directly in your activities. We want the visibility of the Special Rapporteur to increase. So thank you very much also to our Assistant Director who has managed to stay throughout, Lloyd Kuveya. Thank you to the speakers and thank you everyone. Have a lovely day.